When I first came to Palm Beach County many years ago, we represented tenants in mobile home parks, and one of the who were just having their rents raised tremendously. And one of the things that we found to be most effective was that the mobile home park tenants would come in and they would pin their voting card to their jackets before they walked into the courtroom to remind the judge that they were indeed voters and they did have rights too, and it made a difference. I think it'll make a big difference in foreclosures if people observe. So that's my 15 minutes for this one is go observe.
We're still having a problem in my county with the open court issue because they're having them in chambers.
Right.
But one of the things that I'm concerned about...
They thought that would fool you, Sylvia.
One of the things that I am very concerned about and don't know if it's a problem throughout the state is that there was a Hispanic woman I ran into who did not speak English and was going into a foreclosure case, and she called the court and wanted to bring a translator. And what I found out is that because it's a civil case, they don't provide translators. Now, I've been told that if they run into this problem, they continue the case. But bottom line is, I don't know if this is occurring throughout the state, and if it is, it's a huge miscarriage of justice, because I can tell you this woman did not speak one word of English, and I don't speak Spanish. So I'm very concerned that that's going on.
Yeah, I'm concerned about that. When they say, oh, we would continue the case, we have cases reported to us all the time where they haven't continued, where the reason the defendant can't be there is he or she is fighting in Afghanistan or Iraq. And there's a federal law that says, the Service Members Relief Act, that says you can't foreclose on people fighting in Afghanistan or Iraq, active military, and yet those people were consistently thrown out of their homes, and one of the worst offenders in that was Chase. But the other banks were similarly ignoring the law about foreclosing against active duty service members. So if they won't even respect those people, are they really going to respect somebody with a language barrier problem? Probably not. An unrepresented person with a language barrier problem? Probably not. That's probably not.
Do you know how we can identify service members? Because in where the county I'm in, it's very heavily military, but I don't know how to identify.
Well, I'll tell you what you can't depend on. In every one of these cases, the judges is looking for something called an affidavit of non-military service before they finalize the foreclosure, because that affidavit lets them know that the federal law is not being violated. Here's one of the things that happened with those affidavits. People like Cheryl Salmons and her staff signed them without any knowledge of whether the person was actually in the military or not, or even sometimes where they were told the person was in the military, they still needed the documents, so they went ahead and signed them. So number one, there are foreclosure mills that simply lied about the person's military status. But twice now in the last month, I've come across an affidavit of non-military service where paragraph 4 says, after due investigation, we have determined that, say, Lynn Szymoniak is a member, an active duty member of the military. So it should say affidavit of military service. But what I found is the judge is just looking through to see whether that affidavit of non-military service is in there. They're not reading it to see what it actually says. It's the exact opposite. So, a lot of what is getting filed in these cases it's similar to my case, where the Soundview Home Loan Trust owns your mortgage. I don't think so. This guy wasn't in the military. I had a guy call me from Afghanistan. He's on, and he said, the reason I can't be there, Lynn, is when those words came out, I thought, oh my God, how can I help this man? But he was up in Jacksonville, and it turned out he was a military contractor, and not U.S. military, active duty U.S. military, because he had gotten discharged because he had taken shrapnel in his brain and had a period of recovery. He had recovered and was now a military contractor, but he wasn't covered by the act. He just wanted some more time. Did he get it? No. There was a sale date on his house, January 7th, and he's out. And he wrote to me, and we discussed how sad it was, and how wrong it was, but we didn't get much further than that. So that's what's happening with some of these cases.
So let me get this straight. She still has her job, even though she didn't do her job to find out that these people were in the military.
Now, actually, the law offices of David Stern have been shut down too.
But there's he just took over the many Five Guys Burgers and Fries franchises. One of them is on Clematis, and he will soon be. He went from Foreclosure Mill to Burger Mill.
Right. It changes. But
Still has his bar license.
no. Eventually, as these stories broke, and the reason the story broke against David Stern is this very, very determined reporter, Mother Jones. Who's Mother Jones?
Andy Cole.
Andrew Kroll. If you haven't read Andrew's story in Mother Jones on David Stern, I thought when that story got told that arrests would follow, the indictments would happen. There'd be grand juries that pulled these people in and said, no, this is, we have to put these people in jail. But of course, we all know that hasn't happened. And it hasn't happened. DocX was closed down in January of 2009. I know every time that that there's a rerun of the segment I did, because all of a sudden, instead of getting 200 emails a week, I get 2,000. There are people all over the country who are hot on this topic right now, and they know that they are losing their homes or have lost their homes. The ones that don't know seem to be the people who are continuing to do this process no matter what, continuing to use these documents, not telling the courts that the documents are fraudulent, and certain judges who say, I'm only interested. Did you take out a loan? Did you stop paying? Okay, then you're out. And you can stand there until you're blue saying, yes, but I didn't borrow the money from them and they don't own my home, and you will not get that evidence into the record in 90% of the courts in certain states. So, you know, that is a huge problem. I'm going to talk a little now about robo-signing. I wrote a paper for this event today. And I'm going to talk, because I wrote it in the form of some questions, because we often hear robo-signing and surrogate signing. After the piece on 60 Minutes, American Home Mortgage Servicing came forward and sued DocX and said, well, they did come to us and tell us that some of the documents had been surrogate signed. It was a new phrase to me. 32 years of practicing law, surrogate signed had never really popped up before. And of course they didn't want to use the word forgery, so they used the word surrogate signed. This was about the same time robo-signing had broken and become part of the American lexicon because of Jeffrey Stefan and others, and we knew that there were people literally sitting in a room at a table, and their one job was to sign their name 4,000 times a day. That's a robo-signer. They have no knowledge of the contents of the document. They don't know whether it's accurate or not. They have no training. They don't have time to read the document. Their only job is to sign their name. So the Jeffrey...
Or someone else's.
No way, I'm going to get to that. That's But robo-signing is you're signing your own name to these documents. Does that mean that the information in it is more correct or more valid? No. It's still, you're going to find that they're saying trusts are acquiring these mortgages even after foreclosures. When I talk about securitization, we'll talk some about that. So, but robo-signing is by far the more widespread practice. And when the banks said they would do their own investigation of robo-signing, they did an investigation that said no harm, no foul. These people weren't harmed because they would have been foreclosed on anyway. So that was the robo-signing scandal. And then surrogate signing says, I say, Lisa, you may sign my name. It's more likely I may sign hers because mine is way too long. And one of the reasons the name Linda Green was chosen was because of its length and easiness to spell. So I say, Lisa says to me, Lynn, you may sign my name. And that would be what the banks are calling surrogate signing. May that happen? It could happen. Could it happen on a witnessed and notarized document? No, that's a violation of the law. In 2 different states have already said it's a 3rd-degree felony. Well, we're still thinking about it here in Florida. But we may be thinking for a while. So that's what, when you hear surrogate signing, it's similar to robo-signing, but instead of sitting there signing my own name 4,000 times a day, I'm signing Linda Green or Lisa Epstein. And then in other cases, it wasn't Lisa who said, yes, you may sign Lisa Epstein. It was Ron who said, go ahead, Lynn, you sign Lisa Epstein's name. Lisa may not, I chose Ron because he is the head of the Southwest Florida Notaries Association, and the last person on earth who would ever do that. I've been fingerprinted by Ron. You know, he's not taking my word for nothing. He's going to really do it right. So, but that is the other piece of surrogate signing. So, there are some banks and servicers who have come forward and said, she's misrepresenting what we did because we had permission to do this. Even if they had permission, they cannot violate this law. You can't give somebody permission to violate this law, which says it has to be witnessed and notarized. So surrogate signing really is another word for forgery, in my humble opinion. You know, surrogate signing is just signing somebody else's name with or without their permission. DocX was sued by American Home Mortgage Servicing and said, oh dear God, we found out that they did this. And American Home Mortgage, DocX said, and Lender Processing said, when we found out this was going on, we did an examination. There were only about 30,000 documents involved, and we did a complete remediation program. That program did not include telling any homeowner or any county recorder or any bank or any judge that this problem existed. And you can see the lawsuit between those entities right now. They say it went on for a period of about 6 months, but Jeff Dinkton and John O'Brien, who took every document out of their county offices, found that it started as early as 2004. And I think the same thing has been found in Nevada and alleged in the criminal indictments brought in Nevada. So that's why were these practices used is my first question, and it has to do with the volume of loans through this process of securitization. So we're going to make all our money by gathering up a pool of 5,000 homes. Think of those little green monopoly houses. We're going to get 5,000 of those together. The income from those mortgages is going to be what we sell to investors. The income stream from those 5,000 mortgages. We are going to have a person designated to gather all those. That's going to be called the depositor in SEC language. We're going to have somebody responsible. Is there water? I'm losing it. We're going to have somebody responsible for selling these and getting SEC approval. That's going to be called the sponsor or seller. We're going to appoint a trustee when we create this trust. That's going to be the trustee, and we're going to have a document custodian. In this whole process, the only thing that couldn't be done electronically was the actual gathering of the notes and the mortgages. So when you take out money to buy a home, you sign a note, just like when you buy a car, you sign the promissory note, I promise to pay this money back. And then you say, and if I don't, you may repossess my home, or you may repossess my car. So there are two critical documents. The makers of these pools, these trusts, said to possible investors, we are going to be so careful. We are going to be so careful about how we put this together. We're going to check every step of the way that we have all of these notes and we have all of these original assignments to the trust. And we are eventually going to, and almost every single trust document says the same thing. We're going to lock them in the stainless steel vault of our document custodian. Oh, please. Because that was the one step that took actual people picking up a pile of papers, putting them in loan files, delivering them to the next entity and the next entity, and locking them in the vault. Thank you very much. And that was the step that didn't get done. That was the loan documentation file. So that's why, then of course, when they did it, they didn't think it was going to be a problem because the foreclosure rates were so low, but then they went to the well too many times, the foreclosure rates skyrocketed, and they needed those documents. Rather than go into court and say, well, those documents that we promised investors that we had, and we promised the SEC that we had, and we've told to the SEC in the annual reports that we have, don't exist, Judge. But you should let us foreclose anyway because, by God, we meant to get them, and those other people meant to sell them to us. They've probably thought about doing that, and then thought about, going into Judge Arthur Schack in New York or Judge Covington in Ohio, who would have said, I don't think so. I don't think you get that house. And then decided they'll choose door number 2, which is we will hire the folks in Alpharetta, Georgia to make up the documents for us. And they will sit there and sign their names and make up these documents, and we will ship them out to the law firms that are representing the trusts and foreclosures as fast as we possibly can, as fast as we need them, and no one will notice. And the truth is, besides everybody watched the 60-minute segment and a few million other people across the country and the Occupy people, mainstream America still hasn't noticed. So,
Ask a question. Robo-signing, is it just done on foreclosure papers?
no, and that's the lovely part for everyone else. I'm going to get to that question. What was?
When you were talking about surrogate signing, they've also talked about using electronic pens.
Right.
Would you address that, whether that's considered surrogate signing or it's a separate thing?
Well, you can't use an electronic pen without disclosing it on a document that is witnessed and notarized.
Can't be done that way anyway. I have to see you sign it.
Right. The notary has to this, and you know we have an expert on this in our office today, but in our meeting today. But Brian Bly, who was one of the most notorious companies for robo-signing, is Nationwide Title Clearing in Palm Harbor, Florida. They've been at it longer than most, and one of their most notorious robo-signers was a fellow named Brian Bly. Brian Bly had his deposition taken. He was the vice president of many banks and servicing companies, and he signed all these documents. And one of the things, and it was a videotape deposition. One of the things they said was, "Well, Mr. Bly, what is meant by a mortgage assignment?" He'd signed a couple 100,000 of them, taken away hundreds of thousands. Well, he said, "I really don't know. I couldn't tell you." Well, what is meant by attorney in fact? Because you signed as attorney in fact for all these banks. I don't really know that either. I don't know that either. It was just a humiliating deposition, and then it went out over the internet, and the bank went in and got a restraining order to keep the law firm who'd taken the deposition from being able to share it with the public at large. And that stands today. We don't have Brian Bly's videotape deposition available to any of us today because it got jerked off. I mean, some of this I know is a little depressing.
Some of it's still out there, but it's hard to find.
Right. So that's if you sign with an electronic pen, you have to be authorized in that state to sign with an electronic pen, and it's not on a witnessed and notarized document, because the notary's statement says, "Personally appeared before me, the undersigned authority, on this particular day. This person was either known to me or submitted this as identification, and swore that this was true." What was the bank's role in robo-signing? I think this is where I was. Bank of America, for example, owns BAC Home Loan Servicing, one of the biggest mortgage servicers in the country. That's not true anymore. I think they just sold it to Ocwen. And banks are trying to not own a servicing company real quickly now that all of this is getting some momentum. And BAC Home Loan Servicing used to be known as Countrywide Home Loan Servicing, and everything is notarized in Collin County, Texas. They did the same thing. In fact, there is a affidavit of an investigator for the Inspector General of HUD who said that when he went down to that office to interview those employees to investigate these circumstances, his investigation was disrupted and sidestepped by Bank of America. But that he found that people were signing 70,000 documents a month in that Bank of America office, but it's called BAC Home Loan Servicing. So Goldman had Litton, Bank of America had BAC, Chase had Chase Home Finance in Franklin County, Ohio. Wells had America Servicing Company. Now they are all trying to sell as fast as they can, and if you're wondering where Ocwen is getting the money to buy all these servicing companies, since it wasn't on their books anywhere that they had this kind of money, the answer is the banks are lending them the money to buy the company. Please buy my company. Would you like to buy it for $500,000? Here's $500,000, because I do not want this company anymore, because there are attorney generals and who are serious about prosecuting this.